it'd still be.
Okay. Well, remind me to bring it up at the end of the meeting.
So how's it feel to be at the big boys table?
Okay.
How's it feel to be at the big boys table?
I wasn't ready for this.
Sorry.
Yeah.
I couldn't.
Well, I mean, for an enforcement, there's a township has to go first.
Yeah.
Save on my computers, I just go back and change.
God love you. Not just
Right.
like, oh, man, I hope Mark's ready.
Yeah, and since Susan's here in township, yes, they can start. and
That's
then-
usually.
Okay,
To make sure it's working.
Yeah.
It's always not.
okay. Oops.
Hey Beth, can we figure out who the iPhone user is?
Who it is? We got-
Can we ask?
Guess Nate can. Nate's running it tonight, so it's not on my laptop.
Sorry, this is Joe Christmer from Lancaster Sauce Company.
Thank
Oh,
you.
okay.
You got it. Sorry, I couldn't find the button.
On iPhone.
Ready? We ready? At this time, we will call the September 15th, 2025 meeting of the East Hempfield Township Zoning Hearing Board to order. Members of the board who are present this evening are Mr. Kyle, Mr. Luce, and myself, Mark Hanson, Vice Chairman to the board. Also, for the record, we have Ms. Graham, zoning officer to the township, and our legal counsel attorney, Jason Hess, as well. We also have a court reporter with us. One person that's missing tonight is our chairman. And as members of the board and the township staff are aware, Chairman Herb passed away 2 weeks ago. Elam was appointed to this board on January 3rd, 1978, which was almost 48 years of service to the township and this board. He was first appointed chairman of this board in January 1984. And back in those days, the chairmanship was rotated every year. So he was chairman again in 1987 and again in 1989. From then on, he has been reappointed chairman of this board every year since. If my math is correct, that made him chairman for 39 years. Elam always ran the meetings in a very professional manner. In some meetings, his wit and levity would come out. However, in others, he would also show some disdain to applicants' representative if needed. However, he never let that get in the way of being professional. When I first joined this board in 2006, Elam was a great mentor to me my first couple of years on the board. Whenever I had a question or was unsure of something, Elam would always take the time to educate and explain things to me, no matter how stupid I thought the question. Elam's knowledge of the township and his involvement on this board while the township grew over the years is unreplaceable. His passing has left some very big shoes for us to fill, and he will truly be missed. Schedule this evening, we have 3 new cases and any old business that may become before us. This board will hear each case in an informal manner without strict compliance with the rules and procedures used in a court trial. We ask each applicant and any individual interested in a case to step in front of our table and explain the circumstances involved in their application. Applicants may present their case themselves through their attorneys or any other representatives. My fellow board members and I, as well as our solicitor, may ask the applicant questions from time to time during the applicant's presentation or at its conclusions. All persons having an interest in the application will be given the opportunity to ask questions of the applicant, offer evidence of their own, and inform the board of their position on the matter. In the interest of prompt and orderly disposition of each case, however, we ask that interested people refrain from speaking until the applicant's presentation has been completed and the board has had an opportunity to question the applicant. At the beginning of each case, people who are interested in the case should decide whether they desire to be a party to it. Being given the status of a party, that person will be entitled to receive notice of the decision in the case and be entitled to participate in any subsequent appeal or rehearing. Individuals who are not given party status may nevertheless ask questions or present evidence, but will not receive notice of the decision or will not automatically be entitled to participate in any appeal or subsequent rehearing. If you desire to be party to the case, we ask that you sign an entry of appearance form at the appropriate time. Although each party will receive a written copy of the decision, the mechanics of typing and signing the decision will take approximately 4 weeks. We ask that each person who asks a question or makes a statement first state his or her name and address for a court reporter. Lastly, in the interest of time, I will administer the oath or affirmation to all applicants and to everybody and anyone who anticipates making any statement with respect to any of the hearings this evening. At this time, will you all please rise? Under penalties of perjury, you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth. If so, please say I do. All right, please remain standing. We'll salute the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Beth, have the cases this evening been posted and advertised in accordance with the sunshine law and the ordinance?
Have been.
Gentlemen, you have received a copy of the June 16th, 2025 board minutes as presented by our secretary. If there's no deletions, additions, or correction, I ask for a motion to approve the board minutes.
So moved.
Can't take it, I wasn't here.
I'll second the motion. Motion by Mr. Kyle, seconded by myself to approve the board minutes as they've been submitted. I guess we can't approve them, can we?
Well, there's, you have a quorum of 3 and there's 2 of you
Okay.
who were here.
Motion made by Mr. Kyle, seconded by myself to approve the board minutes as submitted. Mr. Luce, how do you vote?
Abstain due to absence.
Mr. Kyle?
Favor.
And I will also vote in favor. Board minutes are approved 2-0-1. Just a reminder to anybody presenting tonight or speaking, we do have several people on Zoom, so please make sure you speak into a microphone so that everybody can hear you. Beth, any old business?
No.
Will you call the first new case, please?
Case number 2492, Landisville Lofts LLC, 335 East Main Street, appeal of notice of violation.
All right, because this is appeal of determination of the zoning officer, it's going to be handled a little differently. I'm going to turn it over to our solicitor to explain it.
Okay, yeah, so under the municipality's planning code, an appeal of a zoning officer enforcement notice, it is the township, their burden to prove that there was a violation of the zoning ordinance. So the township would go first and put forth any evidence they have and any exhibits they have. And then after the township's witness testifies, the appellant's attorney may ask questions of the township's witness. And then after the township rests their case, the appellant may put on their case in defense of the enforcement notice. with any witnesses they have. And then, of course, the township would have an opportunity to cross-examine the appellant's witnesses. So any questions about process? Okay, then I guess the township can come forward.
Good evening, Susan Piper on behalf of the township. I have just one witness this evening, Beth Graham, and if council's okay, I understand she's going to stay where she is, if that works okay. Before I begin, I do have a packet of exhibits that I've taken the liberty of pre-marking, and I'll hand those out. Okay, so I'd like to call Beth Graham as my witness to begin. Ms. Graham, would you please state your full name for the record and your position with the township?
Susan, can I interrupt you for 1 minute, please? I forgot to ask. Is there anybody that wants to be a party to this case? Okay, thank you. I'm sorry.
Could you please state your name and address, or I'm sorry, your name and position with the township?
Beth Graham, zoning officer,
And how long have you served in this role for the township?
3 years and a few months.
Are you familiar with the property located at 335 East Main Street in the township?
I am.
And have you reviewed the township's file for this particular property?
I have.
Who is the record owner of the property?
Landisville Lofts.
All right. And could you generally describe for the board what exists on the property currently?
Currently, it was a restaurant at one point. It's now being turned into residential apartments, 8 apartments, and a parking lot.
What zoning district is this property in?
Village Center.
And what improvements exist on the property? Is there a building?
A building currently.
And is there a parking lot?
There is.
Is the property undergoing improvements currently?
It is.
And what type of improvements generally are occurring on the property?
Just they're turning them into apartments, interior to 8 units.
Is this going to be a multifamily dwelling when
Multi-
it's done?
Yes, multifamily.
And has a certificate of occupancy been granted yet for any of these residential units?
No,
So at this point, no one should be actually residing at the property, is that correct?
correct.
Okay. About how many parking spaces are located on the property?
Between 30 and 40.
If you turn in your exhibit packet to what we have pre-marked as Township Exhibit Number 1, do you recognize this document?
I do.
And what kind of document is this that we're looking at in Exhibit 1?
This is the enforcement notice that I sent to Landisville Lofts.
Okay, who wrote the notice?
I did.
All right, and what is the date of the notice?
July 9th, 2025,
Can you identify the property at issue in the notice?
335 Main Street,
And to whom is the notice addressed?
Landisville Lofts.
What was the method of delivery for the notice?
It was sent first-class mail and certified.
All right. Before we get into the details of this actual notice, before sending this notice, did you in fact issue a courtesy letter to the property owner?
I did.
All right. If you would turn to what we pre-marked as Exhibit Number 2 in your packet.
Are you submitting this as one exhibit or 8 separate exhibits?
I'm going to submit it as 8 separate.
Thank you.
Taking a look at what we've marked as Exhibit 2, do you recognize this document?
I do.
And what is this?
This was the courtesy letter that I sent to Landisville Lofts,
All right, and what is the date of the courtesy letter?
June 13th, 2025.
And before you issued this letter on June 13th, did you go out and visit the property?
I did.
And when did you go visit the property?
I believe probably the day before.
What prompted your visit to the property?
We received a complaint about a food trailer and being modified or renovated on the property,
And where on the property was this?
in the parking lot in the rear of the building.
So you go out to the property in response to a complaint on June 12th. What did you observe when you arrived at the property?
There was a food trailer back there It looked like it had been worked on. It was all black. They had complained of aerosol spray being done to the trailer, and it was all black and it had things, decals on it. And then I also observed a jet ski on a trailer.
When you talk about a food trailer, was this like a box with wheels that gets attached to the
Right.
truck?
Yep, one that you would pull with a truck.
Okay. And the jet ski, I assume just one jet ski on a trailer,
Correct.
also something you would attach to a vehicle to
Correct.
go?
Yep.
All right. Did you meet with anyone when you were at the property on June 12th?
I'm sorry?
Did you meet with anyone?
I did not. There was nobody there.
All right. Did you take any photos when you were there?
I did.
Okay. If you would turn, please, to what we've marked as exhibit number 3. Can you tell us what we're looking at in this exhibit?
So we have a picture of the food trailer and then another picture of the general parking lot where you can see the food trailer, and then to the left is the jet ski. It's hard to see, but I was trying to get a picture of the whole property.
Okay, so let's back up and start with the top photo. There appears to be a black box on some wheels with some blue lettering or signage. Can you tell us what that is that we're looking at in that
That would
photo?
be the food trailer.
Okay. And is there a vehicle parked next to it?
There is.
And then looking at the bottom photo, which I understand you say is a wider view of the parking lot, is that correct?
Correct.
Okay, and the blue that we see kind of in the middle of the back of that parking lot, is that also the food trailer?
That's the food trailer truck and the jet ski to the left.
Okay, and so going from the food truck trailer immediately to the left, is that also the vehicle that you?
Yes,
Okay, and then to the far left of the photo, would that be the jet ski?
correct.
Okay, thank you. When you visited the property on June 12th, were you able to substantiate the complaint that had been lodged with the township?
Yes, I was able to.
Okay. And when you issued your courtesy letter that we have identified in Exhibit 3, Exhibit 2, did you notify the landowner of what the concerns were?
Yes,
And did your courtesy letter cite to relevant portions of the zoning ordinance?
it did.
And what specifically was the concern with regard to this property vis-a-vis the zoning ordinance?
So it was the uses of parking lots, which are, states that they're generally for the purpose of accommodating the passenger vehicles of persons associated with the use. And then also down farther, things that are not permitted in a parking lot would be including service, repair to vehicles, and long-term sale, display, or storage of vehicles.
So in your courtesy letter, did you inform the property owner that you'd made a determination that a zoning violation was occurring on the property by virtue of the parking of this food truck trailer and jet ski trailer?
Yes,
In your courtesy letter, did you ask the property owner to bring the property into compliance?
I did.
Okay, and in your letter, which we've marked as Exhibit 2, did you set a deadline for the property owner to bring the property into compliance?
I did, June 26, 2025.
Did the township hear anything from the property owner in response to this courtesy letter?
Our planning director, Nate Sturgis, received an email.
Okay. And did Mr. Sturgis confer with you about the substance of your courtesy letter?
He did.
Okay. And was there an email response to the property owner concerning the letter?
There was.
Okay. And if you would turn, please, in your packet to what we pre-marked as Exhibit number 5. And is this the email exchange that occurred between the property owner and Mr. Sturgis?
It is.
Okay. And are you copied on Mr. Sturgis' response to the property owner?
Yes.
All right. And did Mr. Sturgis also inform the property owner that based on your review of the situation and the storage of the food trailer and the jet ski trailer, that the property was in violation of the zoning ordinance?
Yes.
Okay. And just so make sure I cover all these exhibits, if you would turn back, please, to what we've marked as Exhibit number 4. And exhibit number 4, is this an accurate representation of section 270-8.5 from the zoning ordinance?
Yes.
As it relates to uses of parking lots?
Yes,
And is this the section of the ordinance that you found the property owner to be in violation of?
yes,
Okay. Now, after your June 26th deadline, did you go back to the property?
I did.
Okay. And do you recall when you went back to the property?
Um, well, after June 26th, I would have gone. So whatever my letter was dated.
Okay. Do you recall what you observed when you returned to the property after the 26th?
The same items were there, the same food trailer, the same jet ski, and the same truck.
Okay. Did it appear to you that either of those items had been moved?
No, I did notice at one point, and I can't remember if it was at that time, but at some point they were moved more forward away from the tree line, but they weren't moved off the property.
Okay. And did you take any photographs when you went back out to visit after the June 26th deadline?
I did.
If you would turn, please, in your packet to what we've pre-marked as Exhibit 6. And looking at Exhibit 6, are these the photographs that you took of the property?
Yes,
And is there a date that you took the photos, or is that represented on this exhibit?
July 9th, 25.
Okay. And walk us through, starting with the top photo in this exhibit. Tell us what we're looking at in this top photo.
The food trailer in the same position and the jet ski.
Okay. And is the jet ski to the far left of that photograph? Okay. And looking at the bottom of the Exhibit 6, can you tell us what we're looking at in the second photo?
So the truck to the right and the food trailer to the left.
And then there seems to be something in front of the truck, a large black box with red and white striping. Do you know what that is?
I believe a dumpster.
Okay. Was the dumpster related to the ongoing construction at the property?
I'm assuming it was. I don't know.
Now, Ms. Graham, did the presence of these items that you observed on July 9th cause you to proceed with issuing the notice of violation that we identified as Exhibit number 1?
Yes.
All right. All right, so if you would please turn back to Exhibit number 1. And this is your July 9th enforcement notice, is that correct?
Correct.
Okay. In your July 9th enforcement notice, did you identify the violation, the specific violation of the township zoning ordinance?
I did.
Okay, and where in this notice in Exhibit number 1 did you identify the violation?
On page 2.
Okay, and specifically, can you tell us where on page 2 you've identified the violations?
The second paragraph down under violation.
Beginning with the sentence, you're currently in violation of section 270-8.5, uses of parking lots.
Yes.
Okay. And did you also describe the actual violation in this notice?
I did.
Okay. And would that be at the top of the page?
Yes.
And at this point, as of July 9th, was the township's concern related just to that food truck trailer and the jet ski trailer?
No, I have observed since then a commercial vehicle parked on the property.
Okay. But as of July 9th, your enforcement notice were the only two concerns at that point, the food truck
Correct.
trailer and the jet ski trailer?
Correct.
Okay.
Sorry, did you say there was now a commercial vehicle parked on the property?
Yes.
Does the enforcement notice, did it advise the owner of the right to appeal the notice?
It did.
And did your notice set forth a time frame for compliance?
I did.
Okay.
August 8th, 2025.
Okay. And to the best of your knowledge, were those conditions remedied by August 8th?
They were not.
Was this appeal then filed by the
Correct.
owner?
Yes.
Okay. When did you last visit the property?
Today.
And as of today, does the food truck trailer remain on the property?
It does.
Okay. How about the jet ski trailer?
Yes.
All right. You testified earlier, there's also a commercial truck on the property?
Correct.
Tell us about that.
It's a very large, I don't know if you'd call it a box truck. I don't know, but it's large. And you can see it from the road looking straight down into the back of the parking lot from Harrisburg Pike. and it's facing out.
Okay. If you would please turn to what we've marked as exhibit number 7.
Excuse me, Susan, can I interrupt you?
Yes.
Just for everybody and for the record, Mr. Bingham has now joined, so we now have 4 members of the
Okay.
board.
Thank you. What we've marked as exhibit 7.
Mhm.
Can you identify what that document is?
That's the commercial truck.
Okay. And the caption on exhibit 7 says 9/4/25 photos by Beth Graham. Are these photographs you took of the commercial truck?
They are.
Okay. You testified you visited the property today.
Mhm.
Can we assume from this photo you also visited on September 4th?
Yes,
Okay. And when you visited on September 4th, was the jet ski trailer and the food truck trailer also on the property?
they were.
Okay. And is it your testimony that as of today, all of those items remain on the property?
Yes.
Okay. Does the commercial vehicle appear to you to be involved with the construction that's ongoing?
So you're objecting? Take a
Do you have a response to that?
Well, it's not part of the notice of violation, but certainly I think it goes to the general use of the parking lot. We can certainly skip it if you want to limit it just to the jet ski trailer and the food truck
Let
trailer.
me consult. Before I'm rendering my decision, would you please give your name for the record, please? I'm going to overrule your objection because this is a picture of a commercial vehicle, which would go along with the intent of the letter of violation. So go ahead.
Thank you. Ms. Graham, did you do any research to determine how long this commercial vehicle may have been parked on the property?
I did. I went on to Google Earth and went date back in time and saw that on the property in 2024, parked in the same spot.
Okay. And have you attached a copy of that picture from Google Earth? And is that part of, is that our exhibits 8 for tonight?
I did.
Okay. And can you point out for us specifically left, right, top, bottom on that page when we're looking at?
To the far left of the building, down the road to the parking
Okay.
lot.
And that would be a white truck behind a red arrow that you've drawn on the photo?
Correct.
Okay. Did you have any discussions with the property owner about the, that commercial vehicle?
At one point, when I spoke with him on the phone, I believe it was, he mentioned that he was renting space to a company. He was renting for their truck to park there. And at that point, I hadn't seen the truck, and then it appeared.
Is the, in your opinion as a zoning officer, does the maintenance of a food truck trailer and jet ski trailer on the property constitute violations of the zoning ordinance?
It does,
Why?
because that's not the use of a parking lot. It's prohibited in a parking lot to keep them there.
Okay. And specifically, does the township ordinance limit the use of parking lots to passenger vehicles primarily? Okay. And does the ordinance pertaining to the use of parking lots also restrict performing service and vehicles, performing service and repair to vehicles in parking lots?
Yes,
Okay. Does the township ordinance also prohibit the long-term storage of vehicles in parking lots?
yes,
Okay. And based on what you've observed, going back to June 12th through today, constitute long-term storage of vehicles in this parking lot?
It does.
All right, thank you. I don't have any further questions at this time.
You have any questions?
All right, good evening, everyone. Like I said, Barley Snyder, Derek Dissinger. My colleague Elizabeth Vanas is here for when we call the landowner witnesses. We just have a couple of questions for you, Ms. Graham. The first is, you said the complaint you received was initially due to smell. Correct? You said you had aerosol was sprayed. That's what
No,
you just
sir.
testified to?
It wasn't due to smell. They witnessed them, they said spraying the truck. And the complaint was children are walking from the pool across that parking lot and it's unsafe for children to be smelling that aerosol spray. That's what the complaint was.
Correct. I thought my question was the initial complaint was due to the smell of paint.
No, there was nothing about smell. It
O-
was that
Okay.
they,
Understood. It was the breathing in aerosol then, not the smell. You said the complaint was for breathing in. Okay. When you visited the property, did you see any service being done to the trailer?
I did not witness them servicing.
And did you see any sales, which is also what's prohibited in that section of the ordinance?
No.
Okay. Before I get into any more of the details, I just want to look at the notice of violation just to clarify a few things. Because the notice of violation is a little bit inconsistent with your testimony. So the right under notice of violation, which is the township's first exhibit, exhibit 1, you wrote, township has a complaint about the food truck and jet ski / trailer. It's not a food truck, correct? It's a food trailer.
Food trailer.
Okay. And I also just wanted to clarify, the notice of violation is not for the jet ski itself. It's for the trailer the jet ski sits on,
Correct.
correct? Okay. Does the township ordinance permit parking and storage of vehicles accessory to the use under the section that you cited? Under, this is in the packet here, under section 270-8.5, uses of parking lots. In your notice of violation, you cut and pasted B, but in a prior communication, you have the whole ordinance section there, correct?
Correct.
So if you read 270-85, uses of parking lots under A, parking lots shall be used for the following activities: parking / storage of vehicles accessory to the use. So an owner of a property is permitted to park a vehicle that he owns on his own parking lot, correct?
Did you say parking lot shall be used?
270-8.5,
Right.
the
Parking
last
lots shall
sentence.
not be used.
So under A,
Let's see.
parking lots shall be used for the following activities: parking / storage of vehicles accessory to the use.
I'm looking at the other. Okay. Parking, storage of vehicles accessory to the use.
So your ordinance does define the term accessory in the definition section. Accessory is additional, something extra, or complementary. So parking, storage of vehicles accessory to the use are permitted in a parking lot, correct?
Yes.
Okay. An accessory to the use, this is approved to be a residential building. I believe you mentioned that in your testimony. So an owner of that building parking a vehicle or tenant of that building, parking a vehicle they own in that parking lot would be permitted under your ordinance as accessory to the use, correct?
Correct, but they're also for passenger vehicles, not any vehicle.
Does not say that in section 1, and I'm sure you're familiar with the municipality's planning code and your zoning ordinance, and the job of a zoning officer is to read the zoning ordinance in accordance with the literal terms that are there. That section 1 does not include the word passenger. I believe you added it in your testimony, but that is not in section 1, is it?
No.
If you look at the rest of the section before you get to B, section 2 permits, and this is not relevant, I'm just trying to put B, which you cited, into context here. 20% of any parking lot can be used for periodic outdoor sale events directly related to the primary use. Again, I'm pointing this out for when we get to B. These events will be no longer than 5 days in duration. So in addition to being able to park your vehicle there in a parking lot, an owner is permitted to use 20% of his parking lot for periodic outdoor sale events related to the use. And then below that, this gives you the authority, correct, that you can issue permits for events unrelated to the primary use, correct? And 3, do you have the whole section in front of you?
I have A, and B.
Yeah, right. So I'm reading under A.
Right.
So you can park vehicles and store vehicles accessory to your use in your lot. You can sell stuff related to your use in your lot. You can also sell things unrelated to the use in your lot if someone gets a permit from you, correct? So going down to B, the section that you've cited for this enforcement notice is the long-term sale, display, or storage of vehicles or other merchandise. Is long-term, are you aware of long-term being defined in your ordinance anywhere? Because storage is permitted under 1. So the section you cited is applying to the long-term sale, display, or storage of vehicles or other merchandise. What do you think that section is intended to cover in light of the fact that you're allowed to park your own vehicles, you're allowed to sell things in 20% of your lot, and it can't last any longer than 5 days, and you can do other things in your parking lot with your permission? So it sure seems like section B2 is applying to the long-term sale, correct?
Hold on. Sorry, go ahead with your objection.
My suggestion would be don't,
I just asked what she thought it
right,
said.
I know, but it was a long question
Okay.
and try to be more precise about what you're asking.
Sure. So in light of the fact that you're allowed to use 20% of your parking lot for,
The chairman.
I need to rule, as chairman, I need to rule on her objection. I'm gonna sustain her objection, please. If you need to put the question in 2 or 3 parts, do so.
well,
And please give her a chance to answer.
sure. So in light of the fact you can use 20% of your parking lot for periodic outdoor sales that cannot last more than 5 days, doesn't it seem like section B2 that you cited is intended to apply to long-term sales, display, or storage of vehicles, meaning longer than 5 days?
The parking lots can be used as accessory to that building, which is a residential unit. What is accessory to that? It's not a business. So how can you do food sales and so on in a parking lot?
You didn't see food sales in a parking lot, did you?
No,
Did anyone
But what is-
complain that there were food sales in the parking lot?
they did not, but you're saying the long-term sale, display, or storage of vehicles or other merchandise. It's a residential building. What is accessory to a residential?
If, we're going to hear some testimony in a second, if the owner or tenant of that building owns that truck, that trailer, excuse me, and conduct sales off the premises, would parking that trailer where that person lives not be accessory to their use?
We don't allow commercial vehicles to park in residential areas.
Where does your ordinance say that? Where does your ordinance say you do not allow commercial vehicles to park in a parking lot? And more importantly, where does it say that in the section you cited in your enforcement notice?
It's not in the enforcement notice, but it does say accessory to the use, and that's a residential unit, a residential building.
If, and
It's
we're
not
gonna,
commercial.
I'm not
That's a
disputing it's,
commercial vehicle parked in the lot.
if you had a tenant who rented an apartment in this building and they worked for Neffsville Heating and Plumbing, that was their job. And they parked a vehicle in a parking space in that parking lot because they lived there. Would you issue an enforcement notice to that individual?
If that vehicle had equipment pulling a trailer, yes. If it was just a personal truck that you drove home at night, different. This is a food trailer. You can't drive a food trailer.
Correct, but in your enforcement notice, you cited that the long-term sale, display, storage of vehicles or other merchandise, and then said the food truck or jet ski must be removed from the property. I don't see anywhere in your enforcement notice any reference to commercial. I don't see any reference in your zoning ordinance to commercial. I know you said you're familiar with the zoning ordinance, the municipality's planning code, and your job to literally read the words that are there. Do you see the word commercial anywhere in the section you cited in your enforcement notice?
I don't. But it's accessory to the use, and the use is residential.
I think you're reading the word passenger vehicle in that section where it is not applicable. So just to be clear, your reference to the jet ski trailer, is that commercial?
No,
If an individual lived in that apartment and put a trailer they attached to their car in that space, is your opinion that would violate your zoning ordinance?
in residential zones, we do not permit trailers to be in the front of a home.
Where was this trailer located?
It's in a parking lot.
Is that parking lot in front of or behind the building?
It's behind the building.
Is there anything you cited in your enforcement notice that would prohibit a trailer that is attached to a vehicle that may or may not haul a jet ski? Is there anything in your enforcement notice that prohibits that if it is owned by someone who owns or lives at the building?
In my opinion, yes. It says parking lot shall not be used for the following activities: the long-term storage, the long-term sale, display, or storage of vehicles or other merchandise. It's a vehicle. It's not a passenger vehicle, but it's a vehicle.
You just said that if that was accessory to a residence, it would be permitted under section A1, correct?
I'm sorry?
If the resident who lived in that building owned that trailer, which we will hear in a second, is the case, that would be accessory to them living in that building, correct?
It's not accessory to a residential use. I'm not sure what you're asking.
Well, I guess I'll wrap up on this. I just read you the definition of accessory from your zoning ordinance. Accessory is additional, something extra, complementary. So a trailer that hooks up to a residential vehicle that is owned by a resident who lives at the building Is that not additional, something extra or complimentary to them living there?
It is.
Thank you. Ms. Fanas, my colleague, is now going to call our landowner witnesses.
Wait,
Oh, sure.
could be some, she might have some.
Okay.
Before the township attorney goes, either one of you gentlemen have a question for the witness? John, do you have any questions for the witness?
No, I don't.
Okay, Beth. And please correct me if I'm wrong here. The term accessory as used in what the applicant is referring to in a dwelling unit would be something that would go along with the dwelling unit. For example, most people would think of shed, in-law quarters, swimming pool, deck, something along that lines, correct?
Correct.
By right, the owner of a property has, can do a home-based business with both with no impact and with impact, correct?
Correct.
Does a tenant have that same right because they technically don't own the property?
It's not a home. It's not a single family dwelling.
But yeah, and I may be wrong here, but I thought I read somewhere in the ordinance in the village zone, impact businesses were allowed, or home-based businesses were allowed.
Home-based businesses are allowed with restrictions.
Thank you.
Can I just ask one question? Looking back on that, and you were talking about the jet ski on there, and they said in the comment of the email that was sent back that the jet ski's been there since the fire. So that was pre-sale for the property?
We'll hear from our witness, but
Okay,
correct.
I just didn't know who owns the jet ski?
The jet ski was left over,
Gotcha.
yeah, from the prior owner. And we'll hear that from our witness in
Okay.
a minute, but his intent's to throw that away when he does his project.
I also have an additional question here. You look at Apple or the township's exhibit number 7. Picture of the white box truck.
Right.
If I'm correct, that was a business in the building before the fire, correct?
That's correct.
So, and that person that owned that business no longer owns the building because Mr. Bowen owns it. Did he buy that truck or?
No, so we can hear this from our witness as well in a minute, but I was sworn in, I gave my oath, and certainly I can testify because he told me, and hearsay doesn't apply here. The seller of the business had an arrangement for some period of time to park his vehicle there after the sale. And I do want to point out, as you mentioned, you're correct, no impact home-based business is permitted in this district and is certainly not limited to someone who owns a single-family home. But also this district specifically encourages shared parking. And it is in section 3.8 B. Oh, sorry, 3.8 G, I believe. And it says shared parking is encouraged within the village center zone. We have an excess, a vast excess of required parking spaces for this use. I believe, you can correct me if I'm wrong in our approval, but I think we needed, what, 8 spaces and have 30 or something like that? It's around there. It'd be in our prior decision, but in terms of our use for this apartment building, there's an excess of spaces, which we thought fit into that section when that deal was agreed upon. But removing the truck, which again is not part of this enforcement notice, is as simple as telling the seller, you have to move your truck now. But we thought that the shared parking being encouraged in the village center zone when you have excess parking would have permitted that.
I believe you're correct that the ordinance does encourage shared parking. However, and I'm not sure exactly what the ordinance number is, I also think it goes into explain that they want some type of written agreement for that shared parking.
Right, which we have. It was part of the agreement when it was sold. But again, that wasn't part of the enforcement notice, and removing it, we had no notice of that until I got here today because it wasn't part of the enforcement notice. But removing that vehicle is not a problem. We're going to hear this in a couple of minutes, but the food trailer is owned by the owner and one of the tenants are both owners of that. And I strongly believe that's no different than someone parking their work vehicle
So
in front of their house.
has that changed since you submitted your application? Because in your application, it doesn't say the property owner owns it, it says his sister-in-law owns it.
We'll hear from, that's Mr. Boland and Ms. Morales. They're both witnesses. They're both owners of it. They both have an ownership interest in it.
Okay. Susan, I believe you had a follow-up question.
And before that, Mr. Chairman, if I could just ask,
Sure.
Beth, did I hear you correctly saying that there have been no certificates of occupancy issued for the apartment? Okay, so there, at this point, there's no legal occupancy of any of the units? Okay, and also, it's somewhat, it was, Mr. Dissinger,
Right.
referred to section A2 about the 20% of the parking lot can be used for periodic outdoor sale.
Right.
And that would have to, it says sale events directly related to the primary use of the lot. So for a residential lot, would that be permitted, sales or any? Okay. Okay, thank you.
Yeah, Mr. S., there's no one selling anything out of the parking lot.
Let me follow up on that. Basically, since that is a residential, multifamily residential, they could have outdoor yard sale in the parking lot, correct? Because that would be related to the multifamily, but they would only be allowed to have 4 of those a year, correct?
Correct.
Okay, that's all I had.
So I'm sorry, Susan, go ahead.
I just want to circle back on 78.5, the uses of parking lots. Am I correct that this is a section that applies to all zoning districts? It's not
Yes,
just applying to
correct.
general? Okay. And again, you've already testified to this, and I appreciate that. The parking of vehicles must be accessory to the use, and in this case, the use is going to be residential, correct?
Correct.
Okay. You gave some testimony, council asked you questions about someone who drives a work truck home.
Mhm.
I think your answer was it depends on the size of the truck. So if someone brings home a pickup truck that says Neffsville Plumbing and Heating on the side, would that be okay as an accessory use to a residential dwelling?
That would be.
Okay. What if the truck was a tractor trailer that said Neffsville Plumbing and Heating, and that resident drove that to and from work every day?
That would not be. We do have, there's weight limits, there's size limits.
And again, your testimony earlier was part of the concern, and the citation here relates to the long-term storage of vehicles.
Correct.
And I believe your testimony was you consider the trailers to be vehicles. Is that correct?
Correct.
Okay. Are those licensed and tagged, those trailers?
They're licensed, yes.
All right, and council asked you about the ordinance provision relating to shared parking. And the language in the ordinance is shared parking is encouraged within the village center zone. Applicant may request a modification and reduction of the number of required parking spaces as specified in Article 8 when 2 or more uses are able to share parking spaces because demands occur at different times. Based on my read of that section of the ordinance, does that apply in this situation?
It does not.
Why not?
Well, there are not two, that would be an example would be if it's a restaurant that only serves lunch till noon, and then in the evening, there is another business that's in the evening, they would share that parking because they only use part of it in the day and part of it at night. That's the intent of sharing it, not renting spaces to businesses.
Does anything about the number of spaces in this parking lot weigh into your evaluation as to whether or not a violation is occurring?
It does because you have to have a certain number of parking spaces per dwelling unit.
And what is
So-
that number?
We would have to, it would be based on the ITE and I can't tell you that without looking at it.
All right, thank you.
Do you have any other witnesses?
I would move for the admission of township exhibits 1 through 8.
We'll accept them all at the end of the assessment. Mr. Dissinger, go ahead and call your,
All right, Ms. Vanas is going to come up and I believe call Mr. Boland.
Good evening. My name is Elizabeth Vanas. I'm here from Barley Snyder.
I'm
as
sorry,
well.
what was the last name?
Vanas. It's a tough one. It's V as in Victor, ANASSE.
Okay, thank you.
So could you go ahead and just state your name and occupation for the record?
Kevin Boland, and address too, right? 783 Church Street, Landisville, PA, 17538. And I'm just for this purpose, member of the Landisville Lofts LLC.
And when did you purchase the property?
February 25th, I believe. February 7th, 2025.
And how did you purchase the property?
At auction in November.
Can you describe the current use of the property?
Currently, it's under construction. We're in the process of outfitting the building to an 8-unit apartment complex. Again, I think we have all required permits except for we're waiting on the sprinkler system permits.
And will these units all be rented out to tenants?
Correct, yes.
Are any currently rented out or are people waiting to rent them?
Who are pre-leased.
Who are pre-leased, okay. So the enforcement notice, and I know we discussed this a little bit, but the enforcement notice that you received back in July, which is marked as Township's Exhibit 1, mentions a jet ski / trailer being stored on the property. Do those belong to you or one of your tenants?
Not the jet ski or the trailer. That was left there.
Okay. Do you have any idea who owns those? Okay. And is your intent that before you get the certificate of occupancy, that you will ensure both the jet ski and trailer are removed?
Yes, the jet ski and trailer will be removed.
So the notice also mentions a food truck, which we've been calling the food trailer. Whose is that?
There's a group of us. So I'm part owner, my sister-in-law, Shagufta, who's one of the pre-leased 1-bedroom units, my wife, my brother-in-law, and my nephew is also a member and owner of the building.
Okay, so it's owned by you as a landowner, your nephew, who is also a landowner since he's the other member of
Yes.
your LLC, Shagufta, who is a tenant,
Yes.
and then another tenant,
No, my wife.
your wife.
Yeah.
Okay, so it's owned mostly, almost wholly
50%
by
yeah.
owners and.
Excuse me.
Correct.
Before you go any farther, I hate to interrupt you, but you keep referring that it's a tenant, but they don't have a certificate of occupancy, so you really can't have a tenant at this point.
Sure. Prospective tenants, let's call them.
Thank you.
So to clarify, Ms. Morales, one of the witnesses here this evening, and Zane are your prospective tenants.
Dane's my partner and Miss Morales is the prospective tenant.
Okay, so she will be living in a unit once the building is
Yes.
completed and you get your certificate and all of that.
Correct, yes.
Okay, so can you kind of describe the food trailer a little bit? Obviously, we went over this isn't the type of trailer you can drive around.
Correct.
This isn't a truck that has, a wheel and stuff inside. So can you describe it a little bit for us?
Yep, no engine, it's just empty, well, not empty, but a trailer that hooks up to a hitch and goes to events and comes back.
So let's talk a little bit about off-street parking and how many spots you have on the property. So Ms. Morales is a prospective tenant for 1 unit, is that correct?
Correct.
Okay. And how many parking spaces do you have on the property?
6?
36, okay. So with 8 units, that's being a little bit generous, 4 spots per unit. That would only be
Yeah.
32, but let's call it 4. The ordinance requires 2 spaces per unit, is that correct?
Yes.
Okay. So I know we talked a little bit, there was some discussion about the size of the trailer. How many parking spaces does the food trailer take up in the lot?
One.
I have no further questions for Mr. Boland. Does the board have any questions at this time?
Before the board, township does.
Well, you indicated tonight that the jet ski trailer is going to be removed. When is that going to happen?
Yeah, we have it scheduled, I'm trying to think of, it was supposed to be closing and finished and on the final dumpster that comes, right now with the permit for sprinkler system, it'll probably be somewhere between October and November.
Isn't it true you told Mr. Sturgis back in June that the jet ski was going to be removed soon?
Yeah, it was supposed to be, yeah, and that's when we were anticipating permits a lot sooner. And then we ended up losing our sprinkler.
It's now September and you haven't removed it. Is there any
Correct.
impediment to removing it now?
Just the cost and the trailer that has, or the dumpster that has to come along with it. And again, I don't know whose it is.
And with regard to the food truck trailer, nobody's living at the property, right?
Not right now, no.
So your only connection or argument you're making tonight is that prospective tenant will be living on the property and will have her food truck trailer.
Correct, and I own the trailer as well.
And the trailer as well. Didn't you tell the township, though, that this was owned by your sister-in-law?
No, it'd be used by my sister-in-law. She's the one who will manage that business.
Are you renting other spaces,
Renting them?
other parking spaces?
No, the former tenant utilizes two of the spots. Again, I thought it went along with the shared. The gentleman who operates the truck lives right up the road. And it was just a matter of convenience for a local resident.
Any rent?
No, nothing.
Is there a reason to ask them to move?
Any birds, you guys?
Do you agree that those are commercial vehicles being stored in the parking lot?
That truck, yes.
That's a violation of the zoning ordinance.
I do, yeah. You know.
Yes. I'm just a little confused with the whole thing with the jet ski and the dumpster.
Yeah.
It can't be just put on something and taken away. I'm just asking,
It was, again, we have it set up that it was scheduled to go in the last dumpster run and it gets taken to the dump and dropped off at Lancaster County Solid Waste Management.
has it been ever put out to see if anybody wants it or anything?
Don't know
Don't
whose
think
it
it-
is, so I don't know how to necessarily sell it. I don't have title to it. It's not mine.
Got it,
I
got
don't
it.
know where it came from. It just was there.
And you own the trailer though?
Correct.
Okay,
The food trailer.
right.
Yes, not the
Okay.
jet ski trailer.
No, I understand that. I just jet ski is not yours. The big truck is not yours.
Right.
But the trailer is.
Correct.
Got it. That's all I have.
Mr. Khan.
Just a question on the ownership of the food trailer. I mean, this addendum to the application clearly indicates that the parking spot was referred to as for her food trailer. So
Correct. She
how does this owned? I mean, how is it titled? What is the
titled my name.
title in your name?
Yes,
And to the extent-
Individually, not in a company's name,
Nope.
individually in your name.
correct.
Sorry for jumping in. To the extent it mentions that the food trailer is Miss Morales's, that's just because she's going to be, as she'll testify later, the manager, basically, in charge of operations of this.
You
business.
can understand our confusion why we thought she was the owner then?
Yes.
My question is, you said it's in your name, correct?
Yes.
Do you have an agreement for Ms. Morales to use that?
To use the food trailer
Use the trailer?
as part of, like, it's a partnership between the four of us. Yes,
For the food business?
correct. And that food business will utilize the trailer. Yes.
Going back to the commercial box truck. Did you say you had an agreement with the original owner to park it there?
They asked if they could leave it there for a certain period of time. Honestly, I don't. Yeah, it was in the contract that we had to allow him since it was continued use. It's been there way past 2024, that it's been at that property. And it's actually, if I remember, I think it was a Metro Express truck, not even Black Knight Tavern truck.
Well, I know Metro Express operated out of the building back before the fire. But, and I can understand part of the agreement said you could use it, but once the truck left the parking lot, because it was gone,
It was out on runs, but it was always parked back there.
because I was there on a Sunday afternoon, it wasn't there.
Again, I'm not there every day. When I'm there, it's either there or I say hi to the gentleman who lives right on Main Street, who walks there to pick it up and go. So he's out on deliveries and doesn't get parked anywhere else.
So in the agreement of sale, that's where this came from, correct?
Yes.
So I can understand how you would have to honor that, but was there no time limit in the agreement?
There was, I honestly don't know what it is, but there was a time limit in the agreement.
I understand it, but
It ends close to when, again, we're anticipating the building to get CO.
so it just seems funny to me that, oh man, I'm going back, memory's not what it used to be, but from previous zoning boards, cases. What, didn't you buy this building back in 2024 at the end of the year?
So he bought it at auction in November. He bid on it at auction, but settlement was in February of this year.
Okay. It just seems funny that it would go for an infinite period of time in the agreement. And part of the reason why I allowed that objection to be overruled is because it does go to the intent of the enforcement letter, that there's a commercial truck sitting on a multifamily residence parking lot. So, the jet ski, you're testifying that that was there as long as you can remember it.
Every time, I mean, I could go back sometime in 2024 and when Glenn still owned it and I was trying to get him to sell it then, it was out there.
Okay, so it's pretty much abandoned.
Yeah.
Okay. Thank you. Anything else? Jason?
Yeah, I have one. Is the food trailer, has it been used? I mean, is it taken out to actually vend?
No, we're in the process of getting licensed. It takes a while from the Department of Agriculture to get the licenses and everything for it. So that's where it's at. It was being decaled, which I think emailed Nate or Beth that we told them no more decaling or anything that they were doing in the parking lot. My sister-in-law was just striping it and we just stopped everything.
That was the extent of the work that was being done in the parking lot. And then it has not yet been licensed to actually use for vending.
Correct, not.
So it's been sitting in the parking lot the entire time.
It was been moved to go get worked on and then brought back. Like, it was moved to have everything installed on the inside and then brought back.
Okay, thanks.
Township, have any questions? All right, continue with your next witness. Oh, I'm sorry. Does anybody in the audience have a question for this witness? If not, go ahead, call your next witness.
It's the yes or no to the appeal.
Can you just state your name for the record?
Clifton Morales.
And can you just give your address for the record as well?
Oh, yes, 783 Church Street, Landisville, PA 17583.
Okay.
38. Sorry.
You hear her, all right?
How do you bring this down?
You can pull that out and hold that.
Oh, yes.
And John might have trouble hearing unless you're talking right into the mic.
No, I heard it clearly.
Good.
Better hear than I do.
All right. Can you just tell us what you will use the food trailer for?
The food tray will be used for making rolled ice cream, different desserts, and also treats.
Okay. And you'll sell out of the trailer?
Yes.
Okay. And are you currently using the trailer for that?
No,
Not yet?
not yet, no.
So, Mr. Bolin just said you're kind of finishing up getting some required licenses.
Yeah.
Where are you in that process about?
We don't know the exact amount, but we applied with the Department of Ag, and we're just waiting for, that process to be,
Okay,
get rolling.
so you've done your applications, you're just waiting for right now? Okay. And will you get all of the permits and licenses required for you to operate the food trailer?
Absolutely.
Okay. So once you get your licenses and permits and start the business, can you kind of describe what you'll be doing with the trailer and what your activities will look like?
So what we'll do is we'll take the trailer to our events, wherever, we'll be in the county, and serve ice cream and treats out of it.
So you'll be hitching the trailer up and driving it off the property?
Yes, ma'am.
Okay.
Mhm.
Would you say you'd be doing that pretty frequently,
We're hoping to do it year-round.
year-round?
That's why we incorporated the treat part. But yes,
So the trailer would be in the parking spot when it's not in use?
yes,
So overnight, things like that?
yes.
Okay. And you will not be selling anything from the trailer when it's parked in its spot on the property?
No.
So you mentioned you drive to different events to sell your ice cream and desserts. How do you find out about those events?
Mostly right now, it's through Facebook and word of mouth. It gets around, so people are aware.
Okay. And I know you mentioned this, but this won't be seasonal or summertime just because of the ice cream?
No,
You'll be year-round?
yes,
Okay.
that's the goal.
And you'll be the main contact person or kind of manager for the business?
Yes,
And will this be your primary job?
yes.
Once it's up and running?
Yes.
Okay. I have no further questions for Ms. Morales. I'll let the township ask some questions.
Oh, I'm sorry.
Microphone, thank you. All right. How long have you had the food truck trailer in the parking lot?
Gosh. Couple months now. Where's Kevin? I don't quite remember the exact date.
Have you ever operated a food truck trailer before?
No,
And you're currently not living at the property, is that correct?
correct.
Okay.
You have any questions?
No.
I have one question. Is the trailer currently licensed through PennDOT?
Yes.
So it has an official license plate on and everything? Okay. John, any questions?
No, you've covered all the ground.
Okay. Anybody in the audience have questions for this witness? If not, go ahead and continue. You'll each get a chance. Susan, go ahead and with your closing remarks.
Thank you. Gentlemen, I think the testimony's been clear tonight that this is a violation of the zoning ordinance, and we would ask that you deny the appeal and uphold the enforcement notice. This is currently under construction for residential use, and the parking lot needs to be for residential use, passenger vehicles and vehicles that may be accessory to that. You've heard the zoning officer testify about work trucks coming in and out. This is a different type of use. This is a food truck trailer. We have violations ongoing. The owner has testified he's aware of them. He hasn't taken any efforts to get rid of them. And so without regard to whether property's been abandoned and without regard to whether, he's got a sales agreement that provides for long-term storage, he's a property owner. He has the obligation to comply with the township zoning ordinance. He's testified he's going to get rid of those items, and that's great. And that's consistent with what he's been telling staff, but we're here, it's September 15th, and they have not been disposed of. The bigger problem, though, is long-term, whether you're going to allow this food truck trailer, whether you believe that that is a reasonable use under the interpretation of the parking lot section of the zoning ordinance. The township submits it is not. It is an unusual use. This is not a work truck going to and from every day. This is a completely different type of use. So we would ask that you deny the appeal and uphold the enforcement notice. Thank you.
Thank you.
All right, thank you everyone for your attention tonight and your informed questions. I really appreciate it. Before I get to the technical reading of the ordinance, which we very much disagree with for a couple of reasons I'll bring up, I just want to zoom out a little bit and bring up two things. One is, we never heard about the Metro truck before I got here this evening. Had I known about that beforehand, we would have told the prior owner to move his truck and that would have been the end of it. The jet ski and the trailer, we do not care about. And as Mr. Bowen mentioned, he'll remove them. As someone who's done significant property development myself, I probably would have given you the same answer that I'm going to stick it in the last dumpster that shows up here, but we don't care about the jet ski trailer. The jet ski is not a vehicle. The trailer, I concede, is. We care about the food truck. And before I get into the technical reading of the ordinance, like I said, I want to zoom out a little bit. We have an owner who owns a property that has 20 extra parking spaces in that property. Ms. Graham testified when special counsel asked her, does the amount of available parking play in your decision? And she said, yes. We have significant extra parking here. The prospective tenant, I agree with calling her prospective tenant. She's pre-leased. She's agreed to live here. This is going to be her livelihood. We have 20 extra parking spaces. Again, I'm going to get to the ordinance in a second because I very much disagree with that interpretation. But are we going to tell a tenant who lives in this building that has 20 extra parking spaces that are not needed for the use, go rent a spot somewhere else, drive your vehicle there, hitch it up, drive it back. When you're done doing the job that you're going to use for your living, go take it back to your rented parking space and don't use any of the extra 20 spaces I have here on my property. Just from a non-legal perspective, I'm going to get to the legal perspective now. That seems like an absurd result under the circumstances. The initial complaint was not smell, but inhalation of aerosol. That has ceased. The initial reason for the complaint is no longer relevant. The only issue is a food trailer that no one can see based on the township's exhibits that is tucked behind a building, not visible from the street, and surrounded by trees. Now, going to the actual ordinance itself, there are three reasons I very much disagree with this interpretation. The first I had pointed out already. The zoning ordinance allows parking and storage. It specifically allows parking and storage. The word passenger does not show up in that section. The word commercial does not show up in that section. All of the words we heard here tonight that were added do not appear in this section whatsoever. The second reason is what is prohibited under B is the long-term sale, display, storage of vehicles or other merchandise. Taken in its context with the rest of the section, which is why I read the whole section, it seems to be prohibiting people from using their parking lot to do sales and display items, other merchandise. Vehicles is listed with other merchandise. The basic principles of statutory construction, I hate that I just said that at this hearing, but that's what the statute's called. The basic principle of statutory construction put those two things together. Vehicles or other merchandise. We're talking about stuff we sell. We're trying to prohibit the sale of these things from a parking lot. In the context of the ordinance, parking's allowed. Storage is even allowed in number 1. Selling stuff in your parking lot under certain circumstances is permitted. What's prohibited is performing services on the vehicles and the sale, display, storage of vehicles or other merchandise. Vehicles is being included with other merchandise. But even more importantly, parking is not in that section. Long-term storage is in that section. I concede that she's not currently operating that business. However, what's the difference between parking and storage? What's the difference between those two things? Because that's relevant here. Parking's clearly allowed in the first section here. Long-term storage is the thing that's prohibited. Long-term storage, to me, and again, under our rules and statutes, use the plain meaning of terms when they're not defined, is a matter of intent. If I take my food truck out, my food trailer, out, every time I want to sell stuff, and I bring it back until the next time I need to sell stuff, that's parking. The thing that's prohibited is long-term storage. We all know what long-term storage is. It's when you take something and leave it there indefinitely because you don't plan on using it for a really, really long time. Parking is a matter of intent. I park my vehicle until the next time I need to use that vehicle, which in this instance, this is going to be her livelihood, is a regular business. That is not under any definition long-term storage. And what was cited in this enforcement notice is the long-term sale, display, storage of vehicles or other merchandise. That is not the intent of what we're planning to do here. And I think coming to a result that someone who lives here that uses that food trailer for their livelihood, to me, that is no different than what I mentioned before of somebody parking their work vehicle in the parking lot. And we are not creating a parking issue here whatsoever. We have 20 extra parking spaces. The only detriment here to having this vehicle here is apparently that it's annoying somebody. Thank you.
Before you step down, I got a couple of questions
Yeah.
for you. What would you define as long-term? Because to me, this goes back to June.
Right.
I would consider that long-term. 3 months?
I actually Googled this, so I'm not finding a good definition. Most people consider the term long-term storage of vehicles to go to your sort of classic example of your classic car convertible that you store in the off-season. That's what most people, everything, I spent a lot of time looking at this earlier today, and that's pretty much the rule of thumb. What do you consider long-term storage? The off-season. 6 to 9 months until you get your car out, take the cover off it and drive your cool classic convertible around. That's what I was able to find. Your ordinance doesn't define that. And again, I'll just point out that what the municipality's planning code says here is if a term's ambiguous, it's ruled in the favor of the landowner.
One of the things that you were, for lack of a better term, suggesting in your addendum to application is this is an accessory to the primary use. Explain to me how a food trailer is an accessory to a residential dwelling.
So I understand your question earlier when you were talking about accessory uses. An accessory use, I agree with you, or an accessory building. I agree with what you were saying. It's a shed that goes with the house. It's a thing that goes to the house. The word that's here is simply accessory. That's it. An accessory, like I said, accessory is defined in your ordinance. We actually know what that word means. It means extra complimentary. She's going to live there. This is where she's going to live. It's her work vehicle. It's accessory to her, to what she does to go to work every day. It's extra to what she does. It's complementary to what she does.
I understand that, but the accessory is used, and you can define it how you want, and the ordinance does define it, but that's an accessory to the primary use. How does a food trailer become a primary or accessory use to a residential dwelling?
Well, it's owned and operated by a person who lives there off premises. They drive it off premises to use it for their job. I'm being totally sincere when I say I don't view that any different than my neighbor who parks his Lancaster chicken box truck outside of his house. He lives there. That's what he takes to his job every day, brings it home, parks it, gets back in it, drives it to his job. That's what that's what Miss Morales is planning on doing here. This is her full-time job when she gets that license.
Okay, thank you.
Chairman, I get a question for both council.
Go ahead.
I guess this is for both council, because it seems like there's some suggestion that there's, gearing up for what's going to happen in the future when she's actually a tenant and the potential for the continuation of this dispute. But what's before the board now and the board can only act on the facts that were given, that were presented with, that at this point, she's not a tenant. And so I don't think the board can render an opinion as to what happens when she does become a tenant. Would you disagree? I mean, that's not part of the.
I do. Mr. Boland, and just to clarify this, because I can tell there was confusion on this, there's a difference between ownership of the trailer and ownership of the business that utilizes the trailer. Mr. Boland owns the trailer. Ms. Morales and the other partners he mentioned own the going concern, the operational business that utilizes that trailer. Mr. Boland owns the building. Mr. Boland owns the trailer. I think pretty much anyone would assume that they could park a vehicle that they own in a place that they live. I dispute the fact that it's been long-term storage, however, which is the even more important part of this, that the notice of violation is for long-term storage. Long-term storage is not defined in your ordinance anywhere, which makes the term long-term an ambiguous term. From the date of that violation to now, I dispute that that's long-term storage. But to go back to your point, if the result of the zoning hearing board in this appeal is that we pay the fine, we move the trailer and we move it back when the building's done, that's fine. The bigger problem is that we don't want to be in a position where that trailer is not allowed to be there when she moves in.
But my point is, I mean, that's going to be an issue for the township to decide whether it's going to enforce. I mean, those facts aren't before the board. That's not the question.
Correct,
before the
but I-
If
board.
they want to maintain the trailer in the future, I think they have to come and ask for a variance of the zoning section. And that is the correct way to do it. And usually you see an application that appeals a notice of enforcement and asks for alternative relief for a variance. And that would have given this board the ability to help craft a decision that maybe this is permitted, subject to conditions. And that, I think, would have, been one way to craft this. But they only appealed the notice of violation, and I agree with you that you have to decide those facts as they exist right now, not on what the intended
Right.
use is going
The
forward.
board can't weigh in on whether they should have requested a variance. I mean, that's not part of the enforcement notice. The enforcement notice is whether they were violating the zoning ordinance based on the facts that were given.
Correct.
Yeah, the answer to that is no, in my opinion. This is not long-term storage of a vehicle within the meaning of your ordinance. Your long-term storage is not defined in every definition that I could find to figure out what the plain meaning of that term is, which is what the Statutory Construction Act says, gave a period far longer than the period that's at issue right now from June to September, which is only 3 months. Everything I could find that defined long-term storage, the minimum time period was 6 months. So I dispute that. And again, your ordinance doesn't define any of those terms. It could, but it does not.
Yeah, and I understand your argument. I'm
Yeah.
just getting to the point of what the board is here to decide.
Correct.
Okay.
Township, any additional questions? All right, at this time, we will close testimony in case 2492. We will take administrative notice of the previous cases, number 783, 802, and 2488, as well as the township exhibits 1 through 8. Number 1, the enforcement notice. Number 2, the courtesy letter. Number 3, the pictures of the supposed violation taken on 6/12. Number 4, Article 8 of the zoning ordinance. Number 5, the email chain. Number 6, the photos on July 9th of 2025. Number 7, the photos on September 4th of 2025. And exhibit number 8, the Google Earth photo. Gentlemen, at this point, I will entertain a motion.
Mr. Chairman, I'd like to make a motion that we take the allotted 45 days that we have to make the decision. I think a lot of things have been brought up here that I'd like to do some research on interpretations myself before I make a rendering.
Do I have a second?
Second.
A motion is second, motion by Mr. Luce to allow the board to take the allowable 45 days, second by Mr. Kyle. Mr. Luce, Or anybody have any comments before we vote? Mr. Luce, how do you vote?
In favor?
Mr. Kyle?
Favor.
Mr. Bingham?
In favor.
And I will also vote in favor. We'll render a decision within 45 days. Thank you. Are you okay? Do you need it? All right, go ahead and call the next case.
Case number 2493, Lorianne Shapori, 2122 Sharon Drive, variance to the setback requirements.
Hi,
Hi.
I'm Lorene Chapery, but I go by Lori. and
Okay.
I've lived at 2122 Sharon Drive for 31 years. I bought the house when I was 34, and when you're young, you don't think about if your house faces north, if your house faces south. And as I've gotten older, you can see by my request for the variance, I've had some health issues. I originally checked into with the township about having a carport, but I don't have 10 feet from my next door neighbor to put a carport beside my house, because I would like to park underneath it to be able to walk in the back entrance without any like rain or snow or anything. So I was denied that because of the footage required. So I'm coming to the board to ask if I could please, if you would please accept my request for a variance. It's only 5 feet that there is a difference in the variance that's required. And honestly, I am not going any further than what my current property already has steps and a sidewalk. So I'm not going any further past the sidewalk. I just want to put a roof over the steps so that way I'm much safer. As I said, I had some health issues. I have a disability placard to drive because I have 3 replacements, joint replacements, with a 4th one pending in the future. So I'm just really looking forward to still living at my house and not, I'm retired now. So I'm going to, I don't plan on moving. So I'm trying to set my house up for long term. And the builder that I'm using has suggested that we put the porch in, and then where it's level on the grass to make a walkway in case in the future, if I would ever need a wheelchair or a walker or whatever. I mean, I'm not that old yet, but that's what I'm looking forward and hoping that you would approve.
Okay. Number one, does anybody wants to be a part of the case? Sorry, got to ask that. All right. Number two, did you have something?
Yeah, I was gonna suggest ask if anyone would be a party.
Yeah. Okay, anything else you wish to add before we ask you some questions?
I think it will truly enhance the appearance of the home as well and the neighborhood properties. So I think it's a plus for my home because it's very bland and very plain rancher. But the reason I'm truly requesting it is for my own health reasons, so that it's safer for me to come in and out of the house in inclement weather.
Okay. Gentlemen, any questions for the applicant?
Yes, you at the present time have no roof over the top of the doorway.
No, no.
Okay, and you're talking about an 8-foot wide porch.
Right. So that it goes, because of the way my grass slopes up, I tend to be on the upside of Sharon Drive where the wind hits. And my house is actually like a vortex in the back because the wind hits and moves around. The man that owned the house before me must have had a problem with the door opening from right to left, because you could tell he changed it to be left to right. But when you exit my front door, There is no room here on the right side. The step ends there. So there's nothing for me. You could easily fall into that bush if it's not trimmed, or fall down further, which would be the worst thing that can happen for me. But I understand why he moved the door, because the wind comes up so high. It probably took the door, and tore it off probably. So I'm assuming that's why he moved it. I don't know that for a fact because he's deceased, but. So I don't mind my door, because when the wind comes up, you can brace yourself, but then I'd have the porch there beside it. So I wouldn't have to worry about falling off.
Has there been any discussion on, will that cut the wind down in the door? I mean, the people that are proposing to build this, have you approached them about it? Is there any,
The people that built it,
or no, that you want to build the porch?
about the wind in the front door? No,
Yes,
we haven't
yes,
discussed
with the
that.
porch on there, will that cut the wind down? Just asking, I don't know. I'm
I
just-
would
Okay,
think so, but I'm less concerned about the wind than I am about walking out right into the rain. When I was younger, when I first built my house, I fell down the steps because there was inches of ice on my steps, my concrete. I have 2 steps and then the sidewalk, and I fell completely down the steps. I did not know that there was ice because it was like that sheer ice. If that would happen to me now, I'd be in an ambulance. So I'm more concerned about not the wind,
I
but
got you.
ice.
I was just
and
asking, yeah, just to see. Okay,
Snow and rain.
and right now you just have steps, concrete steps right up to the doorway.
I have a little sidewalk and then I have 2 steps.
Okay, because I'm looking at the front elevation in the packet that you gave us. And just has steps right in there, no railing or anything to it.
I have a railing on the right side
Okay,
currently right now.
all I have.
No, just to clarify, the variance needed is 5 feet
Yes.
setback
Mhm.
from 30 to 25.
And as I said, I'm not going any further than what my actual walkway is right now. So I'm not really going
no problem.
past that at all.
Yeah, I see that in the plan. Okay, thank you.
Mhm.
So I have a question. If you look towards the rear, you see this, the sidewalk that's showing here? Is that gonna be added or is that there existing now?
No, currently the sidewalk is in the front of the door.
Like right here?
Yes.
And it just goes down here to the driveway?
Well, there, out of the front door, there's a sweep, I guess you'd say.
So is this currently how it looks? You can come up here and take a look at this.
Yes.
Okay, so that's,
And you can see how it's not level.
right.
So that's why he said if I brought a sidewalk down here, it would be level where if I would ever need a walker or a wheelchair, I could just go right down. So yes,
And you said you couldn't put a carport in because there wasn't
I'm not 10 feet, there's not enough room.
between the side property line?
Correct. Mhm. Because my neighbors didn't care. They didn't mind if I would put it up, but I was told that I need 10 feet.
You could got a variance for that too. Yeah.
Now there's a lot.
Oh, there it is, right there. Perfect. So the sidewalk basically is gonna come up here to the new porch, or if it's approved, correct? Basically like this.
Yeah, yes.
Okay.
And as you can see, my house is very small. It's not really big. So the sidewalk looks big on that plan, but it really isn't. It's just a small curve.
And so you're gonna be looking at about, the new porch will be about 20 feet long, about half the width of the house, correct?
Yes.
Okay,
And it's gonna be wood structure, not concrete.
okay.
My builder said to tell you that because I didn't know.
Okay. Jason, you have any questions? Beth, you have any questions? Any other questions for the applicant, John?
No,
Okay. Anything to add? Okay,
no, nothing to add.
in that case, we will take, we'll close testimony in case number 2493. And I will entertain a motion if there is one.
Mr. Chairman, in case 2493 for Lorraine Chapery, 2122 Sharon Drive, Lancaster, PA 17601, I move to grant the variance to section 270-3.5 E2 to allow for a 5-foot variance to the 30-foot front yard setback to a total of 25 feet for the front yard setback with our normal conditions.
And we have a motion by Mr. Luce, in case number 2493 for the property located at 2122 Sharon Drive, Lancaster, PA 17601, to grant a variance to section 270-3.5 E2 to allow a 5-foot, a 25-foot setback instead of the required 30, resulting in a 5-foot variance. Is that your motion?
Yes.
Do I have a second?
Second.
We have a motion on a second. Any comments? If none, Mr. Luce, how do you vote?
In favor?
Mr.
In
Kyle?
favor?
Mr. Bingham?
In favor.
And I will also vote in favor. Your variance has been approved.
Thank you, sir.
You're welcome. Before we call our next case, let's take 5 minutes break and then we'll go back at it.
You gonna run? Are you gonna run the next case and accuse yourself?
All right.
All right. You call the next case, please.
Case 2494 Eastern Richardson Partners LLC, seeking a variance to the setback requirements.
All right, as they're making their way up here, gentlemen, the name of the applicant, Lancaster Sauce Company, has been a previous employer. They were a customer of mine. I hope to make them a customer in the future. So I will be running this meeting, but I will be recusing myself from the vote. All yours.
Good evening, zoning board. My name is Jared Russell. I'm a civil engineer for the Dennis Group. I'm currently representing our applicant here, Jason Smith, who represents Lancaster Sauce Company. Currently, we're here tonight to request a variance on two ordinances. The first one being section 270-3.12E, which prohibits the use of or prohibits accessory use in the front yard. And the second ordinance being section 270-410C, which prohibits accessory structures in the front yard as well. So the property located at 501 Richardson Drive, also 301 Richardson Drive, is currently situated in a scenario where they have two frontages on the lot, one on the north end, which is Plan West in this exhibit, and one to the south, which is Plan East on this exhibit.
Excuse me a sec. Is there a pointer over there?
It's on the, right on top.
Could you, as you're talking, point out what you're explaining?
No problem. So currently there's two frontages on the lot. So we have one on the north side here. Richardson Drive actually wraps around this property, and the second frontage being on the south end of the property here. Lancaster Sauce is proposing a silo pad and also two truck docks that will be used for offloading ingredients to those silos. The current ordinance prohibits this accessory use for those silos in the front yard. And also, they would also fall under the accessory structure ordinance as well. As proposed here, our silos would actually be outside of the 50-foot front yard buffer zone, but is still considered the front of the building, which is why we are requesting this variance. Any questions?
So yeah, it's considered to have two front yards. is what you're
Correct,
saying.
right.
Okay.
Yeah, so technically there is no rear yard. There's two fronts and all side yard.
Actually, township can correct me on this. Actually has three front yards, correct? Because the side yard there is also fronting on Richardson Drive.
Oh, this one here? Okay. All right, I think we interpreted that as a side yard in this exhibit here. But if it is a front yard, yeah, we'll still be outside of that for our proposed work.
I mean, the only reason I say that is because typically the front of the building is the front yard, and in this case, the rear of the building is also the front yard, correct?
It's a very unique property.
And then when you look, the side yard is always down the side of the
Right.
building, so technically, they actually have three front yards to this facility, correct?
Well, there's a portion of the side of the building that is side yard.
Right.
Can I see your point for a minute? The lines on here are generally showing, it's front yard, anything in this general area is front yard. And as soon as you get here,
Side yard. Correct, and that's what I'm saying, so they definitely have two front yards, but you could almost give them 2.5 front yards.
It's very unique.
Chicken nits.
So I have a question. It looks like, are you removing parking spaces to put these silos there? Is that?
Correct. We are proposing to remove parking spaces. Actually, if you can switch over to C101.
Which one?
C101. All right. Yeah, so there are some parking spaces that are currently existing in this area
Still going on?
that are planned to be removed for the silo and the truck dock.
Okay, and is that gonna cause any issues with parking, the number of parking spaces by removing those?
Yeah, so we have ran calculation. Actually, I think I also provided that on the plan itself. I believe it's down here. It was just on that one, that plan that we saw before.
Didn't go the way I expected it to.
So while I was finding that, so the parking calculation was done using the ITE. And that's about here, I believe. This is one of these two boxes. Can't really see it too well.
You say ITE?
Yes, the ITE.
That's a bad word.
Yep, then you can scroll down. Yep, so we had the parking calculation. That's based on the Chapter 5 land use description from the ITE. So using that, we actually do have the required amount of parking spaces, given the fact that we'll be removing some for the silos and that truck dock.
Sure, go ahead.
Can you clarify how much silos you're putting in and what the timing is of that?
Yes, so we're proposing a silo pad that can house 6 silos. 3 silos will be installed in the phase that we're proposing, and then 3 silos will be installed in the future.
Okay, thank you. Just one follow-up. Are you proposing new landscaping as far as the buffer there? I can't tell what's.
No landscaping is
Something different.
proposed in this plan here.
Okay, thank you.
John, you have any question?
No.
Question for the township. Are they required to put screening in?
We haven't evaluated it. Yes, I believe this will require a stormwater plan, and typically that stuff's evaluated then. It's let me pull up the screening requirements.
And while you're looking at, what's the height on these shallow silos?
So one silo will be about 45 feet and the other 2 silos 35 feet.
And that meets all the requirements of the township, Nate?
I didn't hear that, sorry.
One silo will be 45, the other 2 35.
I did a double check, but I believe so. I believe the only restriction he had is, if it were in the airport hazard overlay area, which I don't believe it is.
No problem.
So there would they would require, they would need a stormwater management plan, even though there's no actually new impervious surface? Since they're,
The area is changed, that particular portion's changing the
okay,
use, so it gets evaluated for that. They'll have to do something.
okay.
I recall it's over 5,000 square feet this little project area.
For the land disturbance? Correct, yes. I believe in our letter, we said 7,200, but that can be verified in the letter.
Any other questions, gentlemen?
I do have one, is you have a, part of your, one of these drawings, let's see, which one is it? I guess it's the, pages, where is this in page? It's the one where it shows the truck movement.
That was the last one you had up, yeah.
So it's I think it's like the third to last.
C1 point, or C1.01.
Yeah, I
Yeah,
think it might be
yeah.
101 or
At one
102.
point
D 1.00, okay.
is the drawing, but you see sheets, yeah.
Yeah,
That one.
that one.
Yep.
So is that to show that, will trucks have to back into that spot to, to load and unload at the silos?
Correct. Yep. So the traffic pattern that we're proposing, the trucks will come down onto the north end of the property, come in through the northern entrance, make their way down, and then pull in to the dock from there.
But they won't have to pull out onto the street.
Actually, could you go to the next exhibit? Yeah, so they do pull onto the street a little bit.
A little bit.
Yes.
Any other questions? No other questions. You have a closing statement?
Um, not really a closing statement. It's just really to just describe the request for our proposed work for our client.
Nope.
In that case, we'll close testimony in case number 2494. We will not take administrative notice of the two previous cases because they were both withdrawn. So there's no need to take them into administrative notice. Gentlemen, I will entertain a motion for case number 2494 if there is one.
Mr. Chairman, case 2494, Eastern Richard Partners LLC, parent company of the Lancaster Sauce Company LLC, located at 501 and 301 Richardson Drive, Lancaster, 17601. I move to grant the variance to section 270-3.12E2 to allow for the accessory use to install silos in the front yard stated in testimony, and a variance to section 270-4.10C2 to allow, my apologies, for the accessory structures of silos to be installed in the front yard stated in testimony, with the conditions that stormwater plans and screening, if required, be complied with by the township, and that they comply with all other township requirements.
Okay. A motion by Mr. Luce for case number 2494 for property located at 301 Richardson Drive and 501 Richardson Drive, Lancaster, PA 17601, to grant a request for the variance to section 270-3.12E2 and a variance to section 270-4.10C2 NC2 with the following conditions. Number one, if required, stormwater and screening have to be, meet the township specifications. Number two, any other township, requirements and or standard conditions. Is that your motion?
Did you say screening in there when you said the storm?
Yes.
Okay, thank you. Yeah. That's
Do
good.
I have a second?
Second.
Seconded by Mr. Kyle. Any comments, gentlemen?
I think it's just a hard property. When you have 3 front yards, it's like, holy cow, what do you,
Yeah, it's a challenge.
more power to you.
If there's no other comments, Mr. Luce, how do you vote?
In favor?
Mr. Kyle?
In favor.
Mr. Bingham?
In favor.
And as I said earlier, I will abstain from voting. Your variance requests are granted as requested. Thank you.
Thank you.
All right, before we adjourn, gentlemen, Colebrook Apartments is going to be coming back before us.
Oh,
I know you guys would be all excited to hear that. They have
That day.
requested, what were the dates?
So I likely will only need one more hearing because.
Yeah, that's what they said the first.
Okay. All right, I'm not gonna make any predictions then. But the dates they have requested, which are good for the township's attorney, for the applicant's attorney, and I'm also available, are October 13th, 15th, and 22nd.
Gentlemen, any of those dates work for us? Because the next meeting would be
The 20th.
the 20th, correct?
October 20th.
Okay, do we want to do 2 meetings that week? No, we can't. No, that's not a supervisor's meeting,
I thought they did
22nd,
dates.
right? Their meetings are the first.
We talked to them recently,
I
right?
talked to him today. And I think he said he had the 22nd. I just conferred with him before this meeting now. Is there a supervisors meeting that night?
No, because the supervisor would be the one and, yeah.
Oh, okay. Oh, there's one the 15th. Okay. So I guess the dates would be
I'd
the
rather keep it
13th or
Monday
the
if we could.
22nd.
Well, so would I, but unfortunately, neither one of those attorneys are available
On the 13th?
on the 13th.
Okay.
No, they are available.
It says, you said
Oh, that's
13th, 15th,
13th.
and 22nd.
Wait. You still have another week yet for October's meeting, correct?
The deadline.
August or September 26th.
That'd be next week.
Do you have anything
Do
yet?
you have anything yet?
Not yet.
Can you
I thought
just,
there was something on
can you just not answer your phone or mail for next week?
I could do that.
13 work for you, gentlemen?
I'd rather do 13th, yes.
13?
I'll try, I'm not sure.
I can't give you definite, but I think Mondays are usually,
John, does the 13th work for you?
As far as I can tell, I'll be back from Rehoboth and ready to go.
I should be able to call in if I'm not here in person.
Okay, so you'll be able to.
yeah.
Will that work for you or would you ask Cheryl? What's that? How's her shoulder going? Okay.
We're gonna be on vacation, so.
Well, let's go ahead and tentatively set that for the 13th then. And they actually are coming for variance requests now instead of anything else.
Okay. Why can't they do it during a normal meeting?
I
then?
don't know.
He's already has something at West Lampeter or somewhere.
Yeah.
On the normal zoning board day.
Yeah.
Yeah.
Can't wait till November.
I don't think they want to, I think they want to get this done and over with.
I understand that. That's okay.
I mean, if you have to call in, call in.
Yeah, that's fine.
One other thing, if anybody's interested, Elam services are this Saturday. up at Snyder Funeral Home on Widows Pike,
10 to 12.
10 to 12.
Mhm.
So with that, this meeting is adjourned.
Great job.
Thank you.
Yep.